Hello, good morning, and a very warm welcome to this ICAST webinar. In a fast-changing world, employment law is constantly in the news. However, sometimes it's important to take a step back and remind ourselves of what we really need to know in running our business and in advising others about employment rights, what the traps are, and when it might be worth seeking HR or legal support. To help explain and understand some of these matters, I'm delighted to be joined by Dawn Dixon, a partner at Anderson Southern, who specialises in HR and employment law. An employment lawyer for 25 years, Dawn is recognised as a leader in her field and is described as bringing a pragmatic and focused approach to her client work. An accredited mediator, Dawn regularly provides training sessions on employment law matters for the Chartered Institute of Personnel and Development in Scotland. A member of the ICAST Employment Taxes Working Group, Dawn is also no stranger to ICAST webinars, and we've been very pleased to welcome her to present at previous webinars on employment law matters. And it's great that she's able to be with us once again this morning. Before we begin, just a few housekeeping matters to remind you. You can submit questions anytime through the live Q&A facility, which can be accessed at the bottom of your screen. Questions can be submitted anonymously or only to the webinar if you so wish. We won't identify who the questions come from, so please do not be shy. Please also join the conversation today through the discussion forum, which can also be accessed at the bottom of your screen. This allows you to comment on matters covered by the webinar or discuss them with fellow attendees. We're also recording this webinar and we'll make it available for on-demand viewing afterwards in case you want to refer back to it or share it with others. And you'll also be able to find the webinar alongside the on-demand video at icast.com/webinars. We look forward to receiving your questions, and of course we'll try to get through as many of them as possible. And I know Dawn has a lot of interesting topics to cover this morning, so without further ado, Dawn, it's over to you.
Oh, good morning, Chris, and thank you. Can you hear me okay?
I hear you perfectly, thank you.
Oh, thanks, Chris. Well, good morning, everyone. It's lovely to be here this morning to talk to you on some key developments in the sphere of employment law and employment taxation. And although Justine can't be here, it's great to be here with you all, whether you're out walking the dog or sitting at your desk with me in the background. It's lovely to be here and to have Chris for company this morning as well. So thank you. What I want to look at this morning are really some employment law and employment tax issues, and to provide you with a bit of an update and possibly a bit of a canter through some of the issues that we're advising on that have changed recently, or things that we have on the horizon. And I always think the best outcome to an update is to actually look at it and think most of that was on my horizon, but there are some things that I perhaps need to plan for in advising my clients in relation to some issues we need to put on the horizon. So that's the plan for this morning. But before I look at the agenda, it has been a really busy time in the area of employment law, as it always is, and it's continued to move apace. But we've seen various things on our agenda recently, such as civil penalties being announced as going to increase threefold in circumstances where an employer doesn't have the correct permissions to work in the UK for employees. And so that's in addition to criminal sanctions. So the maximum penalty for that, for example, was £15,000. And we've recently seen that for a first issue or a first breach, that would go up to £45,000. And then 60 for subsequent breaches. So it really is important to do things like those right to work checks. We've seen a number of new employment bills and employment legislation creeping along our agenda, many of which have been on the agenda for quite some time, since the Queen was with us and in her speeches pre-COVID. But we're seeing things such as right to carers leave and neonatal pay and leave come onto the agenda, not in the way that we'd originally anticipated, but through private members' bills. ACAS have also this month issued updated resources for us in relation to the issue of absence and in relation to the issues of managing that absence. So And before I go through the agenda slide this morning, I just wanted to sort of raise that on your agenda, because that's a really good piece of guidance from ACAS in relation to absence. We've seen some parts of the Employment Allocation of Tips Act 2023 come onto the agenda, and that will be enforced from May 2024. And that's really about fairly and transparently distributing tips. And of course, we've seen changes come onto the agenda and move swiftly through in relation to flexible working, and that's something I'm going to talk to you about as we move through this morning. But as the cost of living crisis continues, we've seen a number of things in my sort of working life to date, looking at the cost of living crisis and just changes in employee behaviour. So a lot of advice being provided to employers about second jobs. So HR Magazine reported, I think it was something like 20 million adults in the UK were looking for a second source of income, and about 16% of workers perhaps thinking about a second job, which raises all sorts of issues such as working time regulations and the contract of employment and employee well-being. So that's a bit of a backdrop as to things that have been going on generally in the background. And I suspect in that area, you'll also have seen a number of issues in relation to strikes being prevalent in the press and in our daily lives. And the law, of course, dealing with that in relation to provisions in relation to agency workers. Last year, we saw agency workers being able to be used to provide cover in the event of strikes, and that has now been reversed due to a judicial review. And we've also seen the kind of minimum service levels provisions for public areas such as health, education, nuclear decommissioning, those sorts of public areas where there are minimum service levels provisions permitted to be provided in the event of strikes. So that's all by way of background. And I see, now I move on to the agenda slide this morning, we've got some root vegetables on the slide. And I think really this image wasn't provided by me, but it's one I like. I am trying to eat more healthily. So I think on the carrots, I'll say that in addition, this morning and looking at the topics we're looking at, I think it's really important to look at the roots of matters and the backdrop and really get a grasp of the basics when we're looking at the key developments I'm going to look at for you this morning. So set out on that slide, we're going to look at some key facts and figures in 2023. We're going to have a brief employment status update, a short update on off-payroll working, then hybrid working, flexible working, a bit of taxation, termination payments, and then just a brief touch on some other developments at the end. So that's our agenda for this morning. So moving to look at now employment law key facts and figures, and you'll probably be aware that in April each year, employment tribunal compensation limits go up. They change in April each year, the 6th of April, and that basically sees an uplift in the maximum amounts that individuals can claim when they proceed to employment tribunal and the maximum amounts in relation to other matters. So you'll see there that between April 22 and 23, the maximum limit on a week's pay went up to £643, and that's the amount that we would use for the calculation of statutory redundancy payments, but also basic awards for unfair dismissal. So in an unfair dismissal case, a successful individual will get a basic award and a compensatory award. The basic award is equivalent to a statutory redundancy payment and is calculated in the same way, whereas a compensatory award is loss of earnings from the date of dismissal to the date of the hearing and possibly sometime into the future. And you'll see about halfway down that slide that for the first time we've got breaking the £100,000 barrier, the compensatory award for unfair dismissal sitting there at £105,707, and that's the cap on unfair dismissal in ordinary cases. And it's important to remember in relation to that that's not necessarily, and it's very unlikely to be the amount that an employee would get, because it's also capped at 52 weeks pay if it's lower than that maximum, and in most cases it is. I've said that there are caps on the compensatory award, There are some types of unfair dismissal case that it's important to remember, just as you perhaps advise clients on this area, that such as, if you were dismissed for a reason connected to whistleblowing, making disclosures, or if, for example, you were dismissed for health and safety reasons and anything connected to that cap is not applicable, and it can be potentially unlimited compensation. But what I've put on the slide is just some of the limits that came in April 2023, looking at how those have increased. And in addition to that, we've also seen an increase in what we call, as employment lawyers, the vento bans, which are awards for injury to feelings in the event of discrimination. And as I suspect many of you will know, that discrimination cases can potentially attract unlimited compensation. However, we have what's called vento bans that provide guidance to our judiciary in fixing awards for injury to feelings. And what we've got there, the current rates for that is that the lower band for less serious discrimination would sit at a level of £1,100 to £11,200. The middle band of discrimination, so that's more serious discrimination, perhaps more of a pattern in the discrimination, sitting at £11,200 to £33,700 for the middle vento band. And then for the most serious cases of discrimination, our vento bands have gone up to a band of £33,700 to £56,200, and the previous limit on that was £49,300. So just by way of kicking off with our update, I thought I'd set out for you some key facts and figures, and there are a number of other increases that we've seen in April, but those are the main ones, and I thought I'd just highlight those for you this morning. And I thought I'll hand over to Chris briefly just to look at some tax facts and figures in relation to the current tax rates. If Chris would like to just come in and make a comment on those.
Yeah, thanks. Yeah, as the slide shows, the tax rate came in, there were a couple of changes in the last year. The £150,000 threshold that had applied throughout the UK, that came last year, or was announced last year that it was going to be coming down to take effect from April, and the Scottish Government followed. So the rates of Scotland are relatively well established, although the top two rates did take a 1% increase in the last Scottish budget. The other thing that's important to remember is that national insurance is decided on a UK-wide basis. So the marginal rate of tax, if you're looking at tax planning for any clients that you might be looking at salary versus dividend, the salary calculations might be a little bit more complicated, potentially, depending on the rates of pay that you're looking at. And that's because the top rate of national insurance, sorry, the lower rates, let's say top rate, the rate for the earnings, that kicks in at the UK higher rate threshold. So there's a point in time when you can have you still be paying full national insurance, but be in the case of a Scottish taxpayer. So lots of differences between the different regimes and the interaction with what is devolved and what isn't devolved. And we probably could run a webinar on that subject on its own, Dawn, but you're quite right to put on the slide that the income from employment, self-employment, pensions and property income, that's the only rates of which Scottish taxpayers pay the Scottish tax rates. The taxpayers throughout the UK will pay UK income.
Thanks, Chris. So moving on now to our employment status update, and I think it's fair to say that in recent times a myriad of different working models have developed, and different platforms, with the recent technology developments, that we really are seeing that what was already a murky issue in relation to employment status, self-employed status, and then the medium category of worker that we have in employment law. We've really seen an overcomplication, I guess, in our case law in looking at this issue. And as our working arrangements continue to develop, and I can only see it going in that direction, I think we're likely to see increasing complexity against a backdrop of much discussion going on in relation to how we may simplify matters. So as I'm sure you're all aware, for tax purposes, there are the two categories of status employed and self-employed. But in employment terms, we have three categories of status. We have our employees who have the full gambit of employment law rights. In the middle, we have workers who have rights to a kind of lesser circle of rights, such as rights to national minimum wage, written terms and conditions, paid holidays and pay slips, protection against discrimination, rest periods, limits on their working time, and rights not to suffer a detriment for whistleblowing, things like that. It's not the full gambit of employment rights that employees have. It sits in the middle, and then we have the rights of self-employed workers. And I put on the slide that the recent cases that there has been in recent years a real change in emphasis. Previously, we were considering whether status was employee or worker, and the case is largely focused on that. Whereas now tribunals are increasingly being asked to look at whether someone who's been engaged or purported to be engaged on a self-employed basis is in fact a worker. And that's what a lot of the cases that I'll come on to remind you of have touched on. And many cases have been brought with supportive unions, and in particular, we've seen a lot of cases being brought by the Independent Workers' Union of Great Britain, who I've put up there on the slide. And looking at the cases, just as a reminder, I've picked two very well-known ones, I think, and I think two found self-employment and two found status of workers. So it's just worth just looking at these cases for 5 minutes or so as a reminder. In the Uber case, that looked at whether the duties, and look at the day-to-day arrangements of drivers. The very the widest sort of possible context of that. They looked in great detail at the Uber drivers and whether they were employed on a self-employed basis or engaged on a self-employed basis, or whether they were workers. And the drivers wished to argue that they were workers for the purposes of the Employment Rights Act, national minimum wage, working time regulations purposes. And what the court looked at in Uber was, and what they concluded really was that worker status, they said, was a question of statutory interpretation rather than contractual interpretation. So in the Uber case, there wasn't really much by way of documentation between the drivers and Uber. There wasn't a sort of detailed written contract that could be looked at. But what they said was that a purposive approach should really be looked at in relation to trying to determine whether we've got self-employed status or worker status. And it really developed on the back of AutoCleanse, which said that you can disregard an agreement when it doesn't reflect the true actings of the parties and the genuine agreement between them. And so although in Uber there was no written agreement, the court really said, look, it's necessary to consider the purpose of the relevant legislation here. And they looked quite significantly at the fact that the purpose of the legislation, national minimum wage, working time regulations, is really to protect the vulnerable. It's to protect vulnerable workers who are in a position of subordinance and dependence in relation to the platform that controls their work. And in those circumstances, the courts found in favour of the drivers being workers. But if we contrast that with the Yodel case, and this was a case in the Watford Employment Tribunal, who will ultimately determine the case, but it did go up to the European Court of Justice concerning the worker status for a courier and whether they were a self-employed independent contractor or in fact a worker. And a key issue in this case was, did the contractual right to use a substitute, that ability to send along a substitute, was that fatal to a finding of worker status for the couriers wishing to say that they were workers and for the purposes of the Working Time Directive should be protected. And what they found was that the self-employed status in the Yodel case was genuine. They would, as drivers, use their own vehicles. They could appoint a substitute, but Yodel in that case could veto the use of a substitute if they didn't think that they had requisite skill. that the couriers had personal liability for any emissions of any substitute. And in that case, Yodel didn't have any obligation to provide work, and that the couriers could reject jobs, they could choose their time, they could choose their routes, and could work for others. So in that case, the finding was in favour of self-employment. But then I'm sure you'll also all remember at Pimlico Plumbers, where we had a plumber engaged on a self-employed basis, or potentially on a self-employed basis, who was arguing that that worker status prevailed, and the rights there were under the Employment Rights Act for holiday pay, unlawful deductions from wages, and disability discrimination being claimed in that case. And the finding in Pimlico was on the favour of worker status. Personal service was required in the Pimlico Plumbers case. There was a conditional right to substitute. That the court found that Pimlico Plumbers was not a client or a customer. And there was a real level of integration and control, which was inconsistent with self-employment. So the court in Pimlico Plumbers looked at things like individuals needing to be available for 40 hours to provide work. There were restrictive covenants, and there was the provision of uniform and a branded van. So in Pimlico Plumbers, we had a finding of worker. And then lastly, if we just look at the Deliveroo case, that was the union I mentioned before, the IWGB against Roo Foods, who were trading as Deliveroo. And that was the food delivery by bicycle being looked at by the court, and whether the riders were engaged by Deliveroo under self-employed contracts or whether they were workers, and could seek to look at getting compulsory trade union recognition under Section 296 of the Trade Union Labour Relations Consolidation Act. So it was a union decision looking at whether they could have the right to get compulsory trade union recognition. And in that case, Deliveroo did not see the drivers as their clients. The dispute wasn't about that. It was whether there was an obligation of personal service in this case. The contract allowed substitutes. There was a provision for substitution, and where a substitute was brought into play, then they were engaged and they were paid by the riders. The substitute had to carry the rider's phone in that case, or had to log in on the platform under the rider they were substituting for's credentials. And Deliveroo only really needed to be informed in that case if there was going to be a question of a different type of vehicle being used, which would impact on the timings of the deliveries. And so a substitute was really something that was looked at in this case, but was found to be unnecessary because it was a real discretion on the individuals to decline jobs. And in that case, the decision was in favour of self-employment. So the court there talks about an almost unfettered right of substitution being important in this finding of self-employment. So just a reminder there on the employment status cases, which really illustrate that this juggle between is it self-employment or worker status is absolutely something that we're seeing a raft of cases on at the moment. And why does status matter? From a tax perspective, I've put on this slide that we know that the tax treatment will be different, and we know that status is looked at slightly differently from a tax perspective and an employment perspective. And we know that a finding of one thing from a tax perspective may be a different finding from an employment perspective. And there are cases where that does in fact happen, albeit I'd say those cases are sort of fewer than there being consistency between the tax finding and the employment finding. But it is really important from an employment perspective to think about status because of the bucket of rights that then flow from that status. So in any employment contract, there's an implied obligation of trust and confidence. There are implied obligations to provide a safe system of work and a safe and secure environment. And this sort of implied obligation of mutual trust and confidence that I referred to is the one that employees often found upon when they resign and claim constructive dismissal. They may not resign in response to a breach of an express term, but they say you have breached my implied term of trust and confidence, and therefore I can no longer be expected to work for you, and I'm claiming constructive dismissal, which attracts the basic and compensatory award that we looked at the start of our session, potential compensatory award of up to £105,000. So quite a significant right there where somebody has employment status, but if they had worker status, they wouldn't be able to claim an unfair dismissal for breach of an implied obligation, for an example. A number of core legal protections are aligned to whether you have employment status or worker status. And I mentioned before employees having unfair dismissal rights, whereas workers having lesser rights, but still significant rights to things such as national minimum wage, written terms, paid holidays, protection against unlawful discrimination, rights under the part-time workers rules, rest periods, limits on working time, the rights to seek trade union recognition and not to suffer a detriment as a result of whistleblowing. And then at the self-employed end of the spectrum, those rights are obviously far less rights there when you are truly self-employed. Where we look at the ACAS Code of Practice on Disciplinary and Grievance Procedures, where there should be a performance or a conduct issue, that applies to employees only, with there being uplifts of up to 25% if the code isn't followed in handling internal matters, whereas someone self-employed, you wouldn't, of course, discipline them in the same way. In fact, that would be an exercise of control and something that would go very much against self-employment. Only employees will automatically transfer under the TUPE regulations. There are some authorities in relation to workers potentially transferring under TUPE, depending on the facts of the case, but in the main, employees are those that we have historically known as transferring under TUPE. And then, of course, you've got vicarious liability of employers for the acts of their employees. So if an employee goes off and does something dangerous, causes a personal injury, anything in the course of their employment, the employer will have liability for that, and that will not necessarily be the same for a worker, and certainly different for self-employed individuals. And then the employer's liability insurance obligations and other insuring obligations will be different depending on status. And same with health and safety, greater duties in relation to your employees, and certain health and safety duties may not extend to self-employed contractors. And finally, I've put the significance on there in relation to handling personal data. So under the sort of retained EU version of GDPR, there's different implications in relation to handling data. Quite a lot of clarity on how employees require to handle data and employers, but it's more difficult to get clarity on the obligations of workers in relation to processing data and whether they sit more aligned to self-employment or employment. And it's certainly not clear from the ICO guidance if workers would be treated as employees or self-employed for the purposes of handling data. So in the world of employment law, quite a lot of significance in relation to employment status and why it matters. And in relation to reform, just to touch on that briefly, we have seen several different inquiries relevant to the consideration of is the current legal framework adequate in relation to employment status, particularly when we're coping with the demands of a rapidly developing modern labour market. And quite rightly, there's considerable press interest in relation to sort of any steps by organisations that might exploit vulnerable workers. And I do think this is an area in which we're likely to see a significant overhaul, if I use that word, in the future. Although for now, I would say significant commentary and discussion hasn't really resulted in significant, meaningful developments or change at this point. But we have seen a number of initiatives. During COVID, we saw calls and threats of judicial review if the protections, those health and safety protections that were very important during COVID, to get those extended to the category of worker and others. We saw those developments, and the Taylor Review and the Good Work Plan developments in relation to the provision of a more stable contract for workers. So out of that, there is the Workers' Predictable Terms and Conditions Bill, which would apply to temporary workers, for example, working via an agency after 12 weeks. And so if that were to come to bear, then we would see some changes there in terms of predictable working conditions for those individuals. So whilst it might not tackle the problem of employment status and how we can get some clarity in relation to making sense of the case law, what we are seeing is various initiatives by way of bills and proposed legislation to try and at least, I guess, give more predictability for those working under employment arrangements where status can be complicated and can be difficult, to provide them with more certainty in relation to their terms. And I put on the slide the EU directive on transparent and predictable working conditions and the European Commission proposals. Now, whether they will be brought into our domestic law is different given where we are in relation to Brexit and retention of our laws. But whether those measures, if coming in, will go into domestic law, it remains to be seen, but it's certainly worthwhile keeping on the agenda and keeping an eye on. And there are various other initiatives that will be important. The government has a working group on employment status, and I hope to see that being increasingly active as we move forward, albeit I think probably those of us on the call at the moment may think that perhaps more proactivity would be really welcomed from us as we sort of progress through our day-to-day work. Okay, just a reminder now on off-payroll working, and these are the rules that we all know make sure that a worker or contractor pays broadly the same income tax and national insurance as an employee would. And I talked about going back to the roots and the basics in our agenda slide, and just to remind you that the rules apply if you have a worker who provides services to a client, and that's through usually their own intermediary. And if they would have been an employee, but for the fact that they were providing services through an intermediary, if they would have been an employee, if they were providing services directly to the client, then the rules are engaged. And the rules, the whole thrust and the root of the rules are to prevent avoidance or reduction of tax and national insurance. And I've put there for you just a reminder of the regimes, and mainly in my day-to-day working life, I'm mainly concerned with Chapter 8 and I guess most significantly Chapter 10 and the off-payroll working rules. And that's really where I tend to provide the majority of my advice, or my clients are seeking advice. But the rules do affect workers providing services through an intermediary, an agency or other supplier providing services through an intermediary, and client receiving services in that way. So you'll probably recall that we had sort of a bit of toing and froing. The government announced that the rules would be repealed in September of last year, and that repeal date was to be April of this year. However, the decision was reversed in October of last year. So we are still in the position on the slide in terms of the rules. I've put on the slide for you just some legislation links and HMRC guidance that I always go back to in dealing with these pieces of advice, and I do find them incredibly helpful. So perhaps I can make sure those links are live after the session and can just circulate them all to you. I'm sure you're all very familiar with them, but very useful in handling advice in this area. And then in looking at engagement to which the rules apply, the Chapter 10 rules, I've just set out on the slide for you when the rules are engaged. And that really is the kind of bulk of the advice that I will provide is where you have a medium or large entity with a UK connection. And the other gateway tests are met, and you've got at that point to carry out the employment status determination. And what I find, certainly in speaking with my clients, is the vast majority will tell me when they speak with me initially that they do this on a case-by-case basis. Half of my clients will say that they find the rules easy to apply, and half of them will say they find it very, very difficult. And I'd say a great majority say that they will use the CEST tool. And I've also come across quite a significant number of cases where there is a dispute, and often I have clients tell me that they've resolved that dispute by opting to put the individual on the payroll, and that's quite a common outcome that I see and sometimes clients will take advice earlier than that, and we can kind of look at things in more detail. But that's my sort of recent experience of handling situations in this area. And we also, I think it's probably worthy of mention just to a point here on umbrella companies. As part of the Spring 2023 tax day, the government confirmed that they would shortly publish a summary of responses to the call for evidence on umbrella companies, and a consultation on the policy options to regulate umbrella companies and tackle non-compliance there. So that's a further watch this space. And finally, on status, I've popped a slide in just about where our clients may refuse to engage with the regime, just to remind them of the consequences of that. So that can be 70 to 100% of potential lost revenue, depending on whether any inaccuracy was deliberate or concealed. And really just a reminder of the increasing number of enforcement individuals working in this area, and the potential for us as advisors, if we're not properly applying the regime in terms of our professional obligations, and reports that may be made, and insurance consequences for us if we're not applying the regime as with our utmost care and diligence. I've popped a slide in relation to the national minimum wage. As the wage rates up to April of this year, there was a report published on the 31st of March by the Low Pay Commission, which marked the increase in the rates, but also looked ahead to the rates for 2024 and beyond, looking at the national minimum wage and the national living wage. And I've popped on the slide for you what the main outcomes of that research paper. It's entitled National Minimum Wage in 2023. And those are the main outcomes as to the direction of travel. And I would recommend, if you have time, just to have a read of the report. It's only 16 pages in length, which is quite a decent length, I think, for one of these papers. So just to bring that one to your attention if you've not had time to read it. And I think finally on national minimum wage, just to make a point on the I guess increasing numbers of inquiries we get where employers and organisations may be in danger of making an error in relation to national minimum wage, and still seeing that quite a lot in the sphere of salary sacrifice schemes, but also employers' workwear policies. So just sort of, I guess a reminder of the 200% penalties for any underpayment, up to a maximum of, I think it's £20,000 per worker, but the reputational damage that our clients can endure with the kind of naming and shaming, also being possible for any national minimum wage breach. So I think it's important to remember, I did mention the sort of enforcement having increased in relation to any breaches, and I think that increase is something like, I think we had perhaps 330, something like that, enforcement officers back in 2017 when there were figures, and I think we've got about 450 working on enforcement now. So it's worth just, I guess, advising our clients to do audits of their position in relation to national minimum wage to ensure that they are complying. Okay, a very brief word now on hybrid working. It's here to stay. I bet a lot of you are possibly, on a dog walk, as I mentioned at the outset, in the office. Who knows? We can work from anywhere these days, and hybrid working certainly seems here to stay. And I know a lot of my clients are downsizing premises or refurbing. The number of clients that I speak to, and there's banging in the background because they're refurbishing the space in which they work to have more collaborative space, to reduce desk numbers because of occupancy. And I was asked to contribute to an article by a HR magazine last week about blackout Fridays, where organisations were switching off the lights on several of their floors with a view to saving costs on a Friday where occupancy rates were low. So hybrid working definitely here to stay. But I just put on the slide a reminder that employers need to really consider whether that is something they're introducing permanently now, whether they're continuing to pilot things and look at it on a temporary basis. Because during the pandemic, there was no suggestion that we were bringing about contractual change by virtue of individuals working from home. We were there by virtue of the pandemic, and there was, that was the reason for it. Whereas as we begin to adopt working from home, hybrid working, and various far more flexible working arrangement these days, but we do need to make sure that our clients have their eyes on making sure that they are reviewing policies and contracts to make sure that they are not raising any I guess non-genuine expectations in employees. If the employer intends things to work in one way, the contract does really need to reflect what the arrangement is to be, and whether it's to be a permanent change or a non-permanent change, and just being very clear with individuals as to the direction of travel and what's expected there. So that should the employer wish to make change in due course, that flexibility is preserved. So looking at the contract, looking at insurance policies where individuals are working from home, looking at things like confidential information, how you're going to keep client information secure, and looking at employee tax implications such as expenses incurred when individuals are working from home or computer equipment is provided. And these aren't new issues, but it's something that I think it's important to keep constantly under review, rather than to think we've sorted this now, we have a policy, because it certainly seems to be for a lot of my clients an evolving arrangement, and working practices and working behaviours and patterns are constantly changing. And a move to a new office often sees a kind of change in patterns, with individuals being in the office more, and then they may want to flex back. So just bearing in mind what your documentation says, and is that in line with the way that you are working in practice. I put the hybrid workings, tax implications, hybrid and distance working report on the slide. That is worth a read, just to have a look at that. And just looking at the things that policies should address. So the issues I'm advising on, and I suspect you're all advising on this more than I am, but are things like, what's the employee's permanent workplace and what are the implications? What happens with travel expenses? The provision of home office equipment and the sort of taxable status of that, where the employee becomes owner of it or the employee retains ownership, and the payment of expenses and household expenses. So looking at those areas, and the paper is useful for that. But I'm sure I'll be in touch with a number of you in the months to come in terms of advising clients on some of these issues and how they relate to tax and NI as we go forward. Looking at flexible working, so I would say in this area, we are seeing trends of employers perhaps moving quicker than the law requires. So the Flexible Working Act 2023 has now received royal assent. It is, we're not expecting it to be in force until next year. However, some employers, such as ASDA, are saying, although the Act at the moment isn't saying that flexible working is going to be a day one right, they are going to make it so, and are going to look at increasing more flexibility at this stage, so that they are enhancing the provision for their employees. So we are seeing businesses thinking about offering that flexibility, usually or sometimes, I would say, as a recruitment tool. It's, flexibility is the thing that a number of generations want, and the workforce increasingly wants. And so in terms of getting those real brownie points in the recruitment market, when we are in a very tough market, increased flexibility is something that is really important and really high on employers' agendas. But looking at the nuts and bolts of the Act and what will change, what we will see when the Act comes into force is that, unlike at the moment where an employee can make one request for a changed flexible working arrangement, under the new rules, an employee will be able to make two requests in any 12-month period. So a sort of marginal increase there, I guess. The employer needs to respond to any request within 2 months, which is down from a 3-month period. And an employer can't reject a request until it's consulted with the employee. So that's a change there. And there are also some changes that make it less onerous for an employee in how they frame their request and how they draft it. So I would say that the changes to flexible working rules will make it marginally easier for employees to make marginally more flexible working requests. And I think we will see increased numbers of flexible working requests. As I say, the popularity and need for flexibility in our working lives has never been greater. Looking at the 4-day working week, just a reminder about that, just to keep that kind of on your agenda, that there were, I think sort of 61 companies who trialled a 4-day work week last year. And they worked on average 34 hours across 4 days, and the individuals involved earned their existing salary for the 4-day week. And more than 90% of the participating business said they would opt to continue with a 4-day week, and 18 of the 61 said that they would adopt it permanently. And these 4-day working week experiments took place in various countries across the world, and supporters of it and those that are saying that they will retain it are real fans because of the boost in productivity that was experienced, but also we need to be mindful that there are some critics of the 4-day working week saying it's impractical in certain sectors. And I think from the articles and the commentaries that I've looked at of late, I don't feel there's going to be a huge rush to a lot of UK workers seeing their organisations offer them a 4-day week for their existing pay. That would be my prediction, but certainly there were perceived benefits for those that took place in the pilot, and so watch this space. In relation to taxation of termination payments, I thought I'd just touch on the issues that I'm commonly working with our tax advisors and you in terms of getting advice. And so you'll, no doubt some of you will hear from me for support in these areas, because it's absolutely invaluable when we come from it from different perspectives. And things like getting the tax and NI treatment wrong, I still see that a lot in day-to-day work. There still seems to be from some organisations that kind of belief that the first £30,000 will be paid on termination, will be paid tax-free. And then the job is really to encourage the organisation to look at the background of the payment, the basis of the payment, the intentions, recent reforms in the area, and to kind of build that into consideration of how they are going to tax various payments. So a lot of advice is still required in relation to settlement agreements and how we are going to treat various payments. I've put benefits in kind there. So a recent one I had to advise on was the continued use of a company car and how that was going to be taxed, and share options and share awards as well. That they often sort of certainly ask me to advise in settlement agreements where there's a cash payment paid out as an alternative when cancelling options, and is that subject to income tax and national insurance, and providing advice on that to say, well, yes, in most circumstances that cash alternative will be. I'm still providing a lot of advice in relation to what's taxed as earnings and what do we need to tax when we are paying in lieu of notice under the PEMP calculations. And I have a good sort of handout on that, just trying to simplify that, because I always think it's good to have a quick guide to go back and just refresh yourself on the formula and some worked examples on that. But still seems to be something that some organisations are requiring support on and providing a lot of advice there. In redundancy terms, I think advice I'm often... Excuse me, I've avoided my husband's lurgy. He's been laid up for a couple of days, and I said to him, I bet I'm going to get this lurgy just as I'm presenting. So I do apologise, one and all. I will clear my throat and continue. There we go. I've not been laid up. I'm famous in our house for never quite coming down with the things that other people get and avoiding most of it. So hopefully that was my illness there that you've just experienced in a few seconds. So touch wood. Looking at redundancy, one of the things that I'm often called to advise upon is looking at conditional. So if redundancy payments or enhanced redundancy payments are conditional upon someone retiring or staying on for certain periods, then what's the tax treatment there, and how will those payments be taxed in terms of being able to maximise the position for employees. And in unfair dismissal, recent examples of advice I provided here is in relation to where someone is being reinstated or re-engaged. What is the tax treatment of that payment, where you are treating someone as if they had been employed and reinstating that kind of back pay on re-engagement or reinstatement, and confirming for clients that the taxable nature of those payments. And then in discrimination cases, I'm often looking at is the discrimination related to termination or not? And for more opportunities to say that payment should be tax-free as injury to feelings where the discrimination is not related to the termination and is in advance of the termination. So providing advice in relation to that. And then the writing off of loans is an area that I'm often asked to advise on. And I have to say, I often pass that one on in relation to, is this taxable as earnings? And I think it is, but that's the kind of area that I would engage with you as professionals to get some support there. Other developments I think it's important to highlight, I'm just going to the last few minutes, is the Brazel against Harper Trust case, which looked at holiday pay for those with irregular hours and reached the quite sort of unfair conclusion that those who worked, for example, if you only worked a few weeks in the year, that the outcome of Brazel was that you'd be entitled to 5.6 weeks holiday pay, even if you only worked, for example, 3 weeks of the year. And what that case looked at was the ACAS guidance on the 12.07% calculation of holiday pay for workers who work irregular hours, and that 12.07 coming from 5.6 weeks holiday pay over the 46.4 working weeks. That gives you your 12.07. The employer in that case had followed the ACAS guidance, used that, but that was found to be unlawful. And what they said was, yes, this may result in, I guess, bonuses in terms of holiday pay and more advanced and advantageous positions for part-time workers and those with irregular hours. But you could have a situation in which you look back and you don't count those weeks in which they don't work, and therefore you only count the pay in weeks in which they do work, and they will then get 5.6 weeks pay at their average rate. And a really quite disadvantageous situation when compared with full-time workers. So there's a consultation in relation to this, which will hopefully enable provisions to be brought in to rectify this. And that consultation closed on, I think it was the 7th of July this year. And we need to then await the legislature bringing in provisions that will correct this anomaly, because at the moment it does need corrected. And looking at the aftermath of P&O ferries as well, just for a couple of minutes, we had these measures being brought in by the Secretary of State as a result of the P&O ferries case. But I think the main point to make about that was the use of fire and rehire, where employers are looking at changing terms and conditions, and to point you in the direction of the ACAS guidance there. Now, this was a case where P&O ferries, they shipped back to port a number of individuals, and they dismissed others by video message, dismissing nearly 800 individuals. And so the case in there, it was met with lots of shock and condemnation last year. I'm sure you'll remember. There was breaches of employment law, of national minimum wage, and of safety practices for those at sea, because of course after dismissing these individuals who wouldn't accept the terms, they then sought to bring in rafts of agency workers who were not used to working at sea or as a crew together, and the health and safety implications there were highlighted. So there were a number of measures, 9 in total, recommended by the Secretary of State. And a lot of these measures are difficult to bring in. There are issues with them, and I have a handout on this if anyone is particularly looking at this issue, to provide you with more detail. But I think I reminded about the consultation requirements, where you're proposing to dismiss 20 or more employees in more than 90 days, then you do need to start that consultation within 30 days for 20 to 99 individuals, and 45 days where you're making more dismissals. And just a word on the fire and rehire provisions that ACAS have. It's a very useful guide. Okay, looking at other important developments. Now, we don't really need to go through these slides about what's happening with the retained EU revocation and reform bill, because you'll probably be aware, and you'll have picked this up, I'm sure, in the press, but there were the sunset provisions on the bill mentioned there in relation to what was to happen if EU law was not retained into our domestic law. It was either revoked or retained. And if either of those things didn't happen, then the law would be sunsetted, and the sun would set on it, and the law would be lost. But what we've had in this year, in May of this year, the government has announced that the sunset clause provisions in the bill are being abandoned altogether. Had it not taken this decision, then it would have caused the automatic revocation of EU legislation that was not expressly retained by the 31st of December this year. But we don't have those concerns. EU law will remain. All EU law will remain. And it will remain binding unless it's expressly repealed. And there's a list of legislation to be revoked included in the bill. And some fairly niche employment legislation in there, like posted workers and certain types of drivers. So less significant implications here than we once thought. But what we have seen at the same time are some proposed changes to the working time regulations and TUPE. So there's a proposed, I guess, merger of the European basic rights to 20 days leave and the gold-plated UK 8 days annual leave to a kind of one entitlement of 28 days leave, so that we don't have to treat those different types of leave differently. Possibility of introducing rolled up holiday pay, and the potential removal of a requirement to keep records in certain cases in relation to workforce working hours under the working time regulations, and some proposals to remove the requirement to elect employee representatives in TUPE situations. So that, I think, with a few minutes to spare, takes us through a kind of canter of what's happening in the world of employment law at the moment. And I hope we've got a few minutes to spare for questions, and I ran over longer than I intended, but hopefully we can fit in a few questions, or we can answer them all today via a Q&A document.
Thanks very much, Dawn. That was really interesting, and I think it proves the breadth and depth of the issues that our members and everyone watching this webinar will have to think about. It's certainly keeping you busy in the world of employment, if nothing else. We do have a few questions, Dawn. Hopefully we'll be able to cover them. If we don't have time to cover them all, we can also follow up after the event on the ICAS website. So the first question is to do with you mentioned the change of working location and hybrid working and all the rest of it.
Yeah.
And the question is there a legal risk to the employer if the employee works a different location without telling them where they really are? Or can it be mitigated by making it the employee's responsibility?
Yeah, I mean, certainly your policy would cover the employee's obligations to make sure that there's clarity on where employees are working, and that obligation would be for them to have good communication with you. I suppose there could be risks if individuals are working at various locations. I suppose confidentiality, I guess, if people are, say, they're working at their gym and they've got, individuals looking over their shoulders. I could foresee a number of legal risks where individuals are working in certain locations, but I think those risks could be covered off by policies and procedures which make very clear that if you're going to allow that, if you're going to allow working out with home and office, and some organisations don't, they don't allow deviation from that. But if you are going to allow it, what are the circumstances you're going to allow it? What are the employee's obligations to communicate with you to assess those risks? And there should be a conversation about it before. And then, of course, we've got the issues where individuals want to work abroad for several weeks, and a lot of organisations introducing policies on what the situation is there, these kind of working from anywhere policies, having very, very clear guidelines which you regularly revise and review as the law develops to make sure that you're taking into account those risks. And I'm happy to help anyone with some pointers there if they're speaking to clients about these issues.
I think the one thing I would just thank from a tax point of view is that we need to be careful in terms of any employees who might be working in a different country, because you don't want to find that causes permanent establishment issues, and you probably could have a whole webinar on that subject on its own. So I don't want to open a can of worms, but I just thought I would just mention it just in case the person asking we find that relevant. Another question that we've got is, have we ever seen a situation where someone has successfully convinced a company not to put them on the payroll? That'll be to do with the off-payroll working section that you talked about. I don't know if you've seen that. Because you're working on the employment law side, you might not have seen that happening in practice. I know that lots of employers, lots of engaging, I'll not use the word employers because that'll just confuse and muddy the water somewhat, but a lot of companies that are maybe engaging workers they might be keener to try and make sure that they're not going to be on the hook by not putting someone on the payroll. I don't know if that's something you've seen a lot on in practice in clients.
I've seen the argument made. I'd have to say more often than not, they're unsuccessful in persuading the organisation of that, and it may just be the particular circumstances that I've been involved in. But I would say more often than not, it goes the other way. And I'm trying to think of a situation where I've seen it successfully argued, and it may just be my caseload. But no, I tend to see it end up in the other direction.
Thanks very much, Dawn. Well, we're almost out of time, so thank you again for joining us and for giving us such a comprehensive coverage and overview of the topical employment and law and tax issues that our members need to be aware of. I'm sorry we didn't have enough time to get through all the questions submitted, but we will compile a Q&A document which we'll upload alongside the recording of this webinar, and you can find that at icast.com/webinars over the next few days. And please remember that you can keep up to date with all the latest tax and other professional news, latest information, guides and resources on icast.com. Looking ahead, we have a range of webinars and in-person events to sign up for. Our next tax event is in Inverness, when I'll be giving an update on various topical tax issues following the spring budget and anything else that's happening between now and then. And in upcoming we have Fiona Donnelly, CA, Director of Sustainability at ICAST, will be hosting a session on advising on net zero for clients. That will be on the 12th of September. Keith McPherson, CA, Chair of the ICAST Charities Panel, will be hosting a session on the 13th of September. That will be on Talking Charity, What's New in Financial Reporting. And this will be followed by the ICAST Solvency and Restructuring Conference 2023 on 19th and the 20th of September. We also have a range of other webinars coming up, which are detailed on the screen. Links to sign up to all ICAST webinars and events are available at icast.com/events. So it only leaves once again thank Dawn and of course you, the audience, for joining us today. I do hope that the webinar has been really helpful to you. So until the next time, goodbye.